As Nicola said, my name is Juliet Holden and I work in the corporate responsibility team at Freshfields Bruckhaus Deringer. For those of you on the webinar that haven't heard of Freshfields, I've got a stuck slide. I was going to go to a fancy map of our offices. So we're an international law firm. We have 27 offices in 17 countries. We have around 6,000 staff worldwide and around 2,500 in our London office, which is our only office in the UK. Although we are a law firm, nearly 50% of staff in the London office are not lawyers but are business service staff, so people like HR, IT, secretaries, etc. I'm pretty sure that when you think about firms that might support the Ban the Box campaign, we don't think a law firm would immediately spring to mind, in the same way perhaps that a law firm probably wouldn't be the first place you'd think to look if you had recently been released from prison. Thank you. I believe my slides have now been handed back to Nicola, so great, thank you for that. But we have opened up our recruitment to those with convictions, and I hope to encourage others who are on the webinar to do the same, and in particular to reassure firms in regulated industries or with regulated roles that they can also do the same. So why did Freshfields decide to ban the box? Firstly, our support for Ban the Box follows the firm's long-standing involvement in BITC's Ready for Work programme, which supports people facing significant barriers back into work by working with businesses to give those taking part the skills and confidence to gain and sustain employment. And we support the programme through work experience, job coaching and informal support schemes. Through Ready for Work, we've offered over 270 work placements, and of those, 27 have gone on to be employed at the firm or by one of our suppliers. And in the last 2 years alone, we've employed 10 people through that programme, 2 of whom were still serving prisoners when they signed their contracts and going back to prison every night after work. In 2011, there was a huge increase in the amount of participants referred to Ready for Work who had convictions. And we could very clearly see that work experience for this group was really key to getting them back into work. Having recently been released from prison, you think you've served your time and that you can put your past behind you. But you probably don't realise that having a conviction is one of the biggest barriers people face into work. More than 1 in 4 criminals reoffend within a year of being released from prison, and with no job prospects, it's quite easy really to see why that is the case. So it was through this programme that we began to better understand the barriers that ex-offenders face, and more importantly, the difference that having a job can make. And secondly, if you visit our website, you'll see that we have a statement about wanting to be the leading international law firm, and that one of the ways that we hope to achieve this is by recruiting the best talent that can come from anywhere, regardless of background or culture. And as Nicola said, there are around 9.2 million people in the UK with a criminal conviction, and that's not an insignificant number. And we certainly don't want to exclude all of those people at application stage just because they've ticked a box. By supporting the campaign, we can be sure that we're judging all applicants on their skills and whether they're right for the role first, meaning a level playing field for a large number of people who have convictions. So really, I guess, put very simply, we want to hire the best people for the job. And by supporting the campaign, we've integrated our long-standing CR activity with our mainstream recruitment practice. In order to move our support of ex-offenders away from just being part of our CR commitments, we needed to get support. And that was support from senior partners and senior HR personnel. And what we were able to communicate really clearly was the fact that we had actually already been working really successfully with ex-offenders for some time through the Ready for Work programme. And it was this success clearly demonstrated through the programme that proved to be really vital in gaining the support we needed to drive the change forward. So to be able to implement this change to our recruitment process, it was important for us to understand exactly what we were asking about in order to know how and when we asked about convictions. And there were a number of questions we needed to consider, such as how and when we'd ask about criminal convictions. We took the decision to ask about criminal convictions only after a job offer has been made, and then a decision is made on a case-by-case basis if there are convictions that do need to be disclosed. We also used support from BITC and from NACRO on what other policies we needed in order to ensure a standardised approach across our London office. And we've developed policies and a decision-making process that equip HR teams and recruiting managers to effectively manage disclosure of criminal convictions. And also, I think, as Nicola pointed out right at the beginning, to feel supported when they're doing that. And we've also provided training to our HR teams and recruiting managers, which was also delivered by NACRO. It was also really crucial for us to understand any restrictions within our own industry. We've chosen to ban the box for both our legal and our business service roles, so we needed to understand the differences in recruiting for both of those roles, and more importantly, the differences between spent and unspent convictions. So I know Nicola talked about this briefly at the beginning, but again, just very quickly, the Rehabilitation of Offenders Act enables criminal convictions to be spent after a period of time or rehabilitation, unless the conviction is over a certain amount of years, meaning that after this time, in most cases, you don't have to disclose your conviction to a potential employer. However, some occupations, such as lawyers, require all convictions to be declared, whether they are spent or unspent. So we really had to be very clear on what we were asking our potential employees. We're not legally allowed to ask unregulated business service staff about spent convictions. So perhaps a few technical details to work through, but nothing really that's too onerous. And once we were confident we had the correct procedures in place, we were able to change the wording on our website and on our recruitment materials. I think one of the things that we were most nervous about when we were talking about banning the criminal tick box was the communication that we were doing it, and in particular communication to our partners and our staff. How would people react? Would it be well received? We knew that we wanted to publicly give our support to the campaign, and that if we just quietly banned the box and carried on as usual, we wouldn't be in a position then to influence other businesses to do the same. So we knew that we really had to communicate this, and to date, internally and externally, we haven't received any negative feedback. And that really is a key point. Just talking about communication of our support, we want to shout about our support of the campaign in the hope that we can encourage other businesses to do the same. And also to challenge people's ideas about the types of businesses that they think might ban the box. You know, you wouldn't really expect a stuffy old law firm to do it, especially as we've included all of our roles. But I do hope that other firms, in particular, I suppose, other large corporates and other law firms that may be thinking of banning the box and supporting the campaign, but aren't entirely sure, that they might look at our support and think again. And finally, just a couple of points to leave you with. We have employed talented people with criminal records, and we don't want others to miss out. 9.2 million people have a criminal record, so it really is an issue that really can't be ignored. And approximately 68% of court judgments are fines. So that's hardly something that should ruin someone's career prospects. And finally, I just want to be really clear that this isn't about banning disclosure altogether. We want to know every bit as much as any other organisation if there's an offence that needs to be disclosed. But by removing the tick box from our application forms and asking later in the recruitment process, we're able to consider the suitability of a candidate without being influenced from the outset by his or her conviction. And we think it really is a common sense approach that enables us to recruit the right people with the right skills for the right jobs. Thank you very much. I'll hand back over to Nicola.